Also, I'm going to introduce my panelists in a moment, but I'd like to let folks know that we are going to have a webinar questionnaire pop up any moment now. So if you'll just take the time to go ahead and complete that, we'd be certainly grateful for your input so that we can improve our presentations in the future, and hopefully we can become friends. So with no further ado, I'd like to go ahead and start by introducing my dear friend, Joe Moore. He's the CEO of Psychedelics Today. Joe, would you mind saying a few words about yourself?
Yeah, absolutely. Thanks, Tom. So I am the CEO of Psychedelics Today. We've been around for about 7 years, and I've been studying psychedelics deeply for about 2 decades. So a lot of experience, a lot of knowledge in the space, and we've built our platform up to the point where we have about 4.3 million downloads on all podcasts and lots of blogs, lots of education, and a lot more to come, and a huge event coming up in LA, Convergence, March 30 through April 2. So I would love to see folks there. So thanks for having me today, Tom.
Thanks, Joe, and I'm very excited for Convergence myself. Next, I have here Lizzie Fonkborner. She is my colleague at Zuber Lawler, and she focuses on psychedelics as well as other subject matter areas. Lizzie, do you want to say a few words about yourself?
Sure. Thanks so much. As Tom mentioned, I'm an attorney with Zuber Lawler. I'm based in the Denver office. I focus primarily on plant medicine, including cannabis and psychedelics. I have experience with deals, regulatory compliance, license applications, contract drafting, and all the other good things that come along with regulatory compliance and corporate matters in connection with plant medicine. I enjoy helping new cannabis and psychedelics businesses navigate the complex state and local regulatory frameworks, and have also represented clients before various regulatory agencies. Happy to be here.
Thank you, Lizzie. And finally, last but not least, we have Raza Lawrence, my colleague again at Zuber Lawler. Raza, do you want to go ahead and say a few words about yourself, sir?
Yeah, sure. Thanks, Tom. I'm very happy to be here today, and we're really celebrating the birth of a new industry. We're blazing new trails in the law, and I'm really excited to be part of a firm that's really at the forefront of that movement. I've been practicing cannabis-related law in California since 2009. California was the first state to legalize medical marijuana back in '96, and the first state to legalize sales of marijuana through collectives in 2004. And when I first started doing cannabis law in 2009, it was mostly these unregulated, unlicensed, nonprofit collectives. There was still all kinds of people being prosecuted with felony cases in state and federal court. Prosecutors were ignoring and misrepresenting the law, and we had to really fight for people's rights in the cannabis industry. California started cannabis licensing around 2018. That's when we really saw a big transition to the highly regulated industry we see today. Most of the felony prosecutions went away, and the change to misdemeanors at the most. So it's really excited to be watch this industry evolve over the years. And now I handle all types of regulatory work for cannabis, all types of transactions, criminal and civil litigation, as well as internal and governmental investigations in the cannabis industry. And I'm looking forward to transitioning this into the psychedelics industry. And we're seeing this birth of this industry. Just this month, Oregon started accepting the very first psilocybin licensing applications. And this is a really fascinating field for legal nerds because of the federal state conflict of law issues. It creates all sorts of interesting issues to help clients navigate with. And also it's just an exciting field to be in, because I see it as a way of improving the world, improving people's mental health, and can really feel good about what we're all doing in this space. So really looking forward to helping all the trailblazers out there looking to get in at the beginning of this exciting new industry.
Thank you, Raza. And I'm going to give a shout out to my co-founder and brother, incidentally, Jeff Zuber, who is the head of our psychedelics practice. He is under the weather today, so I'm sitting in for him. So I'm going to thank all the panelists for letting me participate in this exciting discussion. Zuber Lawler has been in this space since 2006 in the plant medicine space. And we're just over the moon excited about this conversation that's happening, not just nationally, but increasingly worldwide. There's a great potential for fungal medicines, plant medicines, to really lift the human condition around the world. And our law firm is very excited about this conversation. We're very excited to speak with you about it. I'm going to go ahead and be nerdy and get a disclaimer out of the way. So pardon me for 20 seconds here. The views expressed by the panelists in this webinar are the personal views of the panelists and not necessarily the views of their respective companies, firms, or clients. The panelists' views should not be considered to provide any type of advice, including financial advice or legal advice. So with that out of the way, let's begin our panel, Legally Psychedelic, the regulatory environment from Oregon to Colorado. I want to start off with Lizzie, with you. And Lizzie, could you kick things off with a brief summary of the Oregon Psilocybin Services Act and what kinds of licenses are available in Oregon? And could you please give the audience some background and explain how someone could apply for specific licenses within Oregon?
Absolutely. Thanks, Tom. Just so happy to be here and talking about these exciting new state-regulated industries. So in Oregon, the final rules for the Oregon Psilocybin Services Program were adopted at the end of December. And the Oregon Health Authority, who's governing the program, has posted the license applications on their website. And as of January 2nd, you can apply to be licensed in Oregon as a facilitator, testing lab, manufacturer, and service center. So those are the 4 license types. The facilitator is the only individually held license. The formal requirements include being over 21, having a high school diploma or equivalent, being an Oregon resident for the last 2 years, and completing an Oregon Health Authority approved training program and passing certain exams. The testing lab does not have a residency requirement, as I will discuss with the manufacturing and service center license types, but it will need to be licensed by the Oregon Health Authority and also accredited by the Oregon Environmental Laboratory Accreditation Program, or ORLAP. The manufacturer license, where psilocybin will be cultivated and processed, does have an Oregon residency requirement in that more than 50% of the ownership interest in the entity that's holding the license must be held by an Oregon resident for at least the first 2 years of the program. An individual or legal entity cannot have a financial interest in more than one manufacturer license. And financial interest is broadly defined in the rules, and it can mean someone who is entitled to a portion of the profits or revenues, or anyone who qualifies as an applicant, which is another defined term, noting that financial interests will need to be disclosed to the Oregon Health Authority. And last, there are location restrictions related to where a manufacturer license can operate. The service center, which is the last of the 4 license types, where the use of psilocybin will occur, has some similar restrictions with the manufacturing, including the residency requirement. There's a prohibition on having a financial interest in more than 5 service centers, which is a bit different than the manufacturer. And there's also location requirements. Both the manufacturer and service center licenses will need to submit a land use compatibility statement with their applications. And this basically demonstrates that the proposed use of the property where they will be located is consistent with the local land use and or zoning codes. In terms of the application, while we don't have time to get into all of the details of the application, the Oregon Health Authority has put up some very detailed guidelines, but I can share some of the overall requirements to give you an idea of what it would entail. So first, the application is made up of several documents. So documents such as an authorized individuals form, an individual and legal entity information form, there are property consent forms. So all of those together will make up the application for each specific license. All applicants must pass a criminal background check and be over the age of 21. Applications must identify all individuals and legal entities who qualify as applicants and fall under the definition of financial interest. So as I mentioned above, the definition of financial interest and applicant and who falls under those is really important to understand because it is the responsibility of the applicant to determine who to disclose to the Oregon Health Authority. All applications require a social equity plan, which must address and include a description of the application of diversity, equity, justice, and inclusion practices and policies, as well as objective performance measures that the licensee will use to evaluate their social equity program. And last, I will just touch on the location requirements. Psilocybin businesses can only be located in a city or county whose state opted into the program. So one of the major steps in applying for a license, specifically for a service center and manufacturer in the lab, is to make sure that where you intend to be located did not opt out of allowing psilocybin businesses in the last November election. And then in addition to the state regulations, just to note that there will be local jurisdiction, time, place, and manner restrictions. And that's my small speech about the license types and application considerations.
Thank you, Lizzie. And you had mentioned a residency requirement. I'd like to focus on that for a moment. And Raza, why don't we hand the mic over to you here? Do you have advice, Raza, for companies outside of Oregon that would like to apply for one of the licenses Lizzie just described within Oregon?
Yeah, absolutely. But before I get into that, I just wanted to supplement the disclaimer that you gave at the beginning. I think this is important based on guidance from various state bar associations around the country relating to cannabis. Lawyers in this field initially in the cannabis area faced kind of a dilemma. There was question about what lawyers could legally do in this field. After all, with cannabis and now psilocybin, we're helping clients basically commit conduct that's totally illegal under federal law. And there's questions about whether our provision of legal services could be construed as aiding and abetting or engaging in a conspiracy to violate federal law. And this is a field where the Controlled Substances Act imposes severe criminal penalties. And there's also potential discipline from state bar associations for engaging in misconduct as lawyers. So our licenses are on the line. We've studied this closely. And what we've concluded based on the guidance from state bar associations in multiple states is if we have to give this disclaimer off the bat and make it very clear that participating in Oregon's psilocybin licensing system, it's illegal under federal law. Same with Colorado's. But the state laws do allow it. They have tightly regulated systems that you can participate in. And as lawyers, we're allowed to advise in this field as long as we make clear the federal law and the conflict between the federal and state laws, and as long as we're not helping clients conceal violations of the law. So based on this, guidance, we're comfortable working in this area, but we wanted to give this disclaimer off the bat to make it clear the legal landscape that you're navigating in. But we as lawyers, we're also jumping into this field like the clients without knowing exactly how the federal government will react, how the conflict of law issues will play out. But I think we have at least a good educated opinion on it based on how the cannabis industry works. And we'll get into this a little bit later, but we're hoping that the federal government will take a hands-off approach as it's done in cannabis, where people are following a tightly regulated state industry and operating within the guidelines of that state law. But this is certainly an interesting area where the federal law and the state law are totally in conflict. Getting into the nuts and bolts of the Oregon application, it just opened this month. January 2nd, the state started accepting applications, and naturally people all over the country are interested. This is the very first and only licensed psilocybin program in the country. And a lot of people are wondering how they can jump into it if they're not in Oregon, but they want to explore operating there. What can they do? So Oregon has a law saying that any psilocybin licensed business has to be majority owned by an Oregon resident. There's some question about whether that passes muster under what's called the Dormant Commerce Clause. It prevents states from passing laws that discriminate against or place substantial burdens on interstate commerce. There's been some litigation in this area in cannabis, which sometimes gives certain benefits to in-state residents. I think it's certainly a real question whether Oregon's residency requirement is constitutional under the federal law and the Dormant Commerce Clause, but it is the law. We have to operate within the context of that law, until we hear otherwise from the courts. And the good thing is there are solutions to get involved in Oregon, even if you're not currently based there. If you're not a resident, you can participate in the program, but you have to find an Oregon partner, someone who's lived there and has evidence that they've lived there for a couple of years. that person needs to be the at least the majority owner of the licensed the licensed psilocybin business. Now, what does that mean if you're live out of state and you're the one investing the money in this situation? Well, there's different solutions that people can put in place to sort of minimize the disruptions of this residency requirement. First of all, you can do a management agreement. The entity that's holding the license in Oregon needs to be majority owned by an Oregon resident, but you're allowed to have an outside management company come in and manage the business, basically. That doesn't hold equity, but it receives management fees. This is very common in the cannabis industry. So you can structure the management agreement in a way that arrange the finances in whatever way makes sense for all the parties involved. So the Oregon resident is still getting fairly compensated for their role in the process, but the managers can basically get incentive-based compensation. It's common in cannabis for the management company to get a percentage of revenues before any profits are distributed. And these are compensation for management services. And based on everything in the Oregon law for psilocybin, it seems like this is certainly possible in operating in the psilocybin license space. And basically, you can adjust those management fees however makes sense, so that the finances work out for everyone. The other thing you can do is have a solid operating agreement in place for the licensed entity, where even if the Oregon resident owns a majority of the business, they don't necessarily have the right to unilaterally kick out other managers, make decisions that are going to substantially affect the business. You can have a super majority requirement, so that the Oregon resident can't by themselves do things that might ruin the business. So getting that operating agreement in place and making sure everyone's rights with each other are clear and are not going to hurt the non-Oregon resident is very important. And then the final thing is the Oregon residency requirement. Right now, it just lasts until 2025. So what a lot of people have been talking about is you can have right in your agreement with the Oregon resident that they either are required to sell back their interest or have an option or the non-resident has an option to purchase the resident's interest in 2025. And you can even do that for a set price that's very low, from my understanding. So there's ways to structure this where the Oregon residency requirement isn't necessarily going to be an impediment to operating in this space, even if you're not from Oregon yourself. You need to find an Oregon partner, and who knows, maybe you'll end up really loving that partner and wanting them to remain a part of the business. But there's ways that you can structure things to have options going forward, so this really won't hurt you too much.
Thank you, Raza. Joe, let's turn it over to you. Joe, you're a thought leader, obviously, in our still emerging industry here. As a thought leader in the psychedelic space, what are your impressions of Oregon's Psilocybin Services Act and Colorado's Natural Medicine Health Act?
Huge steps forward, 100%. It's the first time it's ever been done in the United States this way. And we're really showing the whole world that it's possible in both Colorado and Oregon. I'm partial to the Colorado law. I live here, but it also expands the scope far beyond psilocybin. In Colorado, we have access now, or will, to DMT, mescaline, and iboga or ibogaine. So in addition to psilocybin and psilocin, so there's a lot of interesting opportunities beyond psilocybin there. And I think the mental health market, the addictions market, it's going to be really helped by what we're doing in Colorado. And I'm just excited to see what's going to happen over here in Oregon. I'm really, really hopeful for a lot of folks to apply and get rolling. And let's start learning and doing business there.
Thanks, Joe. Raza, on that same note, Lizzie, pardon me, what are the main differences between Oregon Psilocybin Services Act and Colorado's Natural Medicine Health Act, as somebody who's focused intensely, I think, on both markets?
Yeah, so Colorado's Natural Medicine Health Act really did two things. And the first thing that it did, as Joe mentioned, was decriminalize the cultivation, personal use, and possession and sharing of DMT, ibogaine, mescaline, not from peyote, and psilocybin. And then the second part is that it provides for a state regulated program similar to Oregon for adults 21 years of age or older to have access to natural psychedelic medicines, starting with psilocybin. So there are similarities, but some of the two main differences that I have picked out from the two is that Colorado does not have a residency requirement. So that being said, I can't predict what the regulations will say, as those are will be drafted. But so perhaps they will require someone who is in charge of the day-to-day operations to be a Colorado resident. But as of right now, we don't see any restrictions on the ownership in terms of residency. Another major difference between Oregon and Colorado pertains to the service centers and healing centers. So in Oregon, as mentioned earlier, psilocybin use can only occur in a licensed service center. In Colorado, we will have healing centers, which are roughly the equivalent to the Oregon service centers. But under the Colorado Act, healing centers can share the same premises with other healing centers or healthcare facilities. And healthcare facilities are defined in the Act to include things such as hospitals, hospice, community mental health centers, and long-term care facilities, just to name a few. And in addition to that, the final rules must allow for locations that are not owned by a healing center, where natural services can be provided by a licensed facilitator, including healthcare facilities and private residences. So Colorado contemplates an avenue for psilocybin use at a private residence where Oregon does not have that avenue in their program right now.
Thank you, Lizzie. Joe, let's a lot of our discussion in this industry relates to profits, the corporate perspectives, and so forth. But of course, there's a very large, a very important component of this conversation that is nonprofit, that's religion based and so forth. So let's focus on that for a moment. What are your thoughts as to religious inclusion in the regulatory and non-regulatory frameworks that we've seen in Oregon and Colorado so far? Joe.
Sorry. Yeah, in Oregon, the state could have done a better job. One of the biggest issues I saw, beyond having jumped through normal hurdles for commerce here, are that these people are creating a sacrament and a la the mushroom and consuming it in their religious ceremonies. But the way the Oregon law is structured is such that that sacrament has to go out of their possession to get tested in a lab that they don't necessarily control and isn't really in line with their practices or beliefs. So I think that's one of the most difficult things for me around the Oregon law. And there was some substantial efforts by some of our partners in Oregon to help really shift that perspective, but the regulators eventually chose not to go that direction. In Colorado, it was actually, I believe, by design that right away after this bill was voted in and the governor ratified it, that religions could effectively operate with near zero risk from the state or local municipalities under this decriminalized frame. So religious groups, yes, there are some possession limits, but they're really not very well defined. But religious groups now can possess, practice, cultivate these four broad classes of psychedelics, and it actually transcends that state level RFRA thing that I hope we have a moment to get into, Raza, later. But it's a really just a far more open framework in Colorado, and I'm really excited about that and see what kind of innovation that brings, because these processes, these treatments are going to be really expensive in the clinical medical frame, and religions would be able to bring this stuff to people in need at much lower rates. So I'm hopeful for that.
Thanks, Joe. And Raza, let's stay on that topic for a moment. What are some psychedelics churches, and how are they using the substance in this industry? Based on
so psychedelics have really been a key part of religion for thousands of years, really, in cultures all around the world. There's a long history of psychedelics being used as a part of religious ceremonies. and as a means to sort of induce transcendental thoughts, getting closer to the spiritual world, and really kind of transforming the mind and kind of inducing religious experiences. The Mayan and Aztec cultures specifically use them in religious festivities, well documented until the Spanish conquerors came along and forbid those practices in some instances, but these traditions have carried on. There's a cave mural in Spain suggesting that Europeans used psychedelic mushrooms in religious rituals as long as 6,000 years ago. And it's interesting, there was a study done at Boston University back in the 60s where subjects were going to a religious 2.5-hour religious service, and some of them were given psilocybin, some of them were giving a placebo, and they kind of reported on their experiences afterwards. And the people who received the psilocybin and participated in the religious ceremony had experiences that were indistinguishable from those experienced by mystics. And they talked to these people 20 years later, and they still thought that this really had a profound experience that really affected their lives in a positive way, and they expressed appreciation for having participated in the experiment. So really, psychedelics, a lot of people believe, can be used to enhance religious experiences. Now, and there's a lot of interesting legal issues. Psychedelics churches, what are the constitutional rights? Joe mentioned RFRA. We'll get into that in a little bit. But basically, right in the First Amendment to the Constitution, it protects the free exercise of religion. And you would think, off the top of your head, if you think if your religion involves taking psychedelics and you're not hurting anyone else by doing so, well, isn't that free exercise of religion? Is it protected? It seems clear cut that it should be allowed, but the law is actually a little bit more complicated. There was a 1990 Supreme Court case called Smith. It actually came out of Oregon, that sort of cut away at what people thought were their religious rights to use psychedelics. In that case, Oregon had denied Oregon was basically not allowing people to use psychedelics, but they had a general law. It wasn't targeting religions. It banned psychedelics in all purposes, and the Supreme Court came out and said that doesn't violate the free exercise clause because this is a law of general applicability. Then if it ends up stopping people from practicing their religion, basically too bad, because it's a general law that applies to everybody. Now, in response to this decision, there was a lot of backlash, and the U.S. Congress passed RFRA in 1993, the Religious Freedom Restoration Act. It had huge bipartisan support, and basically that law said that the government's not allowed to substantially burden the free exercise of religion, even if it's a law that has general applicability to everybody, unless they can show two different things. First, they have to show that it's a really compelling government interest that this law is advancing, and then they have to show that it's the least restrictive means possible to advance that interest. And that ended up protecting a lot of religious activity that was caught up in these sort of general laws, but where the government really didn't have a compelling case to stop that religious activity. Notably, this law, it doesn't apply to states. It only applies to federal laws that prevent people from practicing a religion. But this still would provide protection against application of the Controlled Substances Act and the federal laws against people practicing their religion. And also, after this federal law, a number of different states have passed their own versions of RFRA, their own religious freedom protection laws that prevent general state laws that end up affecting people who are trying to practice their religion. It protects those rights. Notably, lots of states have passed these. Oregon and Colorado have not. So it'll be interesting to see how these license programs kind of interact with religion in those states. There have been a couple of other Supreme Court, well, there's a Supreme Court case in 2006, the Gonzalez case. And in that case, the Supreme Court held that the government had no compelling interest in enforcing the Controlled Substances Act to stop the sacramental consumption of ayahuasca. The Supreme Court, they looked at all the evidence. They said that, first of all, there's no evidence that it was a serious health risk at all. There's lots of evidence, on the other hand, that it can be done safely. And basically, the Supreme Court found that there was no compelling interest to enforce this federal Controlled Substances Act law when people were using it as part of a religion. No one was getting hurt, so it's protected. Another case 3 years later, a federal district court case in Oregon, involving a church called the Church of Holy Light of Queen. The federal judge there held that members of this church were allowed to import, distribute, and brew ayahuasca, despite the federal Controlled Substances Act. And in that case, there was a lot of discussion of whether this was a sincere religion, or whether this was essentially people trying to use religion as an excuse to do this. And the court looked at the evidence and found that this was a sincere religious practice of the sacramental consumption of ayahuasca. There was testimony from the church leaders that they had studied this religion for 21 years, traveled to Brazil to learn from church leaders, and that basically their practice contained all the trappings of a traditional religion. So we have now different examples where showing that this religious activity is protected against enforcement of the federal law. Now, in response to this, you see people sometimes setting up these psychedelic churches, cannabis churches. You see sometimes too that sometimes they're essentially just storefronts that call themselves a church, and people thinking that that's going to somehow make their activity totally legal. And it's not easy to show. You have to show that this really is part of a sincere religion. It can't be something that you just made up. But it is a potential legal pathway, at least under federal law, if it is part of a legitimate religion. What is a legitimate religion? That's a tough question to answer. Who's to say that your religious beliefs are not sincere? But there are standards that they look at in terms of whether this is part of a real religion. And there are cases we've seen now where people have past the hurdles and establish this, but it's not easy. You can't just call yourself a church and get away with this. You have to really put it within the framework of a legitimate religion.
Thank you, Raza. And by the way, we have a number of questions coming in through the chat window. So a few of these we'll try and answer on the fly as we go along, but we're also going to address questions, rest assured, toward the end of this webinar. So keep submitting questions as you like, and we look forward to answering them. Joe, any final, before we move on to federal legality, any other thoughts you want to contribute to this vital religious component to the conversation?
Absolutely. Yeah, it's just quite absurd that the DEA is now the organization in charge of letting us know if our religions are sincere or not. And we don't really, well, I personally have some problems with the DEA. So I just think that's quite absurd. And there was a recent lawsuit from this church in Florida called Soul Quest, and they actually had their application denied, which is quite unfortunate for religious freedoms in America. I'm hopeful that they'll win in their countersuit, but it's important that we get all this stuff sorted out. And some warnings to folks: just be careful around trusting religious leaders in the space, because it's not explicitly clear that without Supreme Court protection that we are safe, even if we have state and federal RFRA to protect us. And I'm sure we'll expand on that in a little bit. But yeah, there's just so much room for innovation here and growth of communities that I'm just really hopeful for this to really take off in the next few years.
Great. And I think one of the overall messages there is that that religious exemption is not a blanket that applies to this, where you just say the word church and you're okay. It's much more complicated than that, and the thresholds are pretty high here in order for that exemption to apply.
Yeah, if I could just expand on this issue of the DEA. In 2009, the DEA came out with the supposed guidance regarding petitions for religious exemption from the Controlled Substances Act, pursuant to RFRA. And there's a process where you can actually apply to the DEA and get approval for their exemption from the Controlled Substances Act. My understanding is not a single religious group has been granted this exemption by the DEA in the years since then. And there's a lot of question whether this process by the DEA is legitimate at all. There's no federal law that gives the DEA authority to regulate churches or determine whether any particular religious group is exempt from the Controlled Substances Act. And also the DEA's registration process, it could be seen as a unconstitutional prior restraint on the free exercise of religion. And it could also be seen as violating a person's constitutional right against self-incrimination to the extent it requires church leaders to sign statements under oath describing conduct that violates the Controlled Substances Act. So anyone who wants to rely on the free exercise of religion to justify their psychedelics activity, you might be better off bypassing the DEA and leaving it to the courts to basically sort it out, because it doesn't seem like the DEA is really your friend here.
Thanks, Raza. Lizzie and Raza, this is for you. Can you walk us through some of these issues relating on that notion of federal legality or illegality, more precisely, relating to psychedelics? And in particular, what are some of the parallels that you've seen with cannabis, and what issues do you think businesses entering the state-regulated psilocybin markets will face as respects federal illegality?
Yeah, I can give a little summary of this issue. Basically, just like cannabis, the new psilocybin laws are granting approval for federally illegal conduct that's state licensed. So it's really teeing up this conflict of laws issue, and we now have several years of experience with the cannabis industry to give at least a clue of how it might play out with psilocybin, but no one really knows if it's going to follow the exact same path. It's really too early to tell, with the first licensed psilocybin just opening up this month. I think everyone's going to be watching how the federal and state laws interact with each other in Oregon, and whether the feds are going to try to do any type of enforcement in Oregon. Basically, the issue with the federal state conflict, it comes down to, in the US Constitution, there's something called the Supremacy Clause. It says if federal law and state law conflict, then federal law trumps the conflicting state law. The federal law controls. And in Oregon and also Colorado, these psilocybin licensing programs, they do clearly violate federal law. It's an obvious conflict. Psilocybin is a Schedule I controlled substance under the Controlled Substances Act, and it's subject to very harsh federal criminal penalties, sometimes decades or even life in prison, subject to federal asset forfeiture laws. And just because Oregon and Colorado are licensing this, it doesn't change the federal law. It's still federally illegal. Some people might wonder, how does the federal government even have authority to come into these states and regulate the psilocybin activity if it's occurring within a single state, and there's no interstate transactions? The Supreme Court has addressed this issue and made pretty clear that the feds do have the constitutional authority to come in and do this. There's an old case called Wickard versus Filburn from 1942, where the Supreme Court looked at the case where there was a farmer who was growing wheat on his own land to feed to his own animals. You would think that's not even commerce, let alone interstate commerce, but the Supreme Court said that this does fall under the federal government's authority under the Commerce Clause, which allows them to regulate commerce among the several states. And how is this regulating commerce among the several states? Well, the Supreme Court said that you can't just look at this one farmer. You have to look at the cumulative actions of thousands of other farmers who'd be growing their wheat. And by doing so, they would be reducing the amount of wheat that's bought on the open market. So if you look at all of them together, they're somehow substantially affecting interstate commerce. So that gives the feds the power to go in and regulate. taken to its logical conclusion, that would seem that the federal government can basically regulate any conduct, because if you look at the cumulative activity of thousands of people and whether it has an effect on interstate commerce, well, almost anything you look at is going to pass that test. There was a challenge, though, with respect to cannabis on this issue. In 2005, the case of Gonzalez versus Raich, the U.S. Supreme Court was faced with the issue of whether the feds could come in and interfere with people who were producing and using homegrown medical cannabis. There were no transactions, nothing crossing state lines, but they said, just based on the logic of Wickard versus Filburn, that this was likely to substantially affect interstate commerce, even if it was meant for local use. It could go into the black market. So basically, the result we're left with is the feds have the authority to come in to go after people, even for solely intrastate activity occurring within a single state, this psilocybin. So we're hoping that the federal government doesn't exercise that power, and based on how they've treated cannabis over the years, we're hopeful that it'll be a hands-off approach, but we're still kind of waiting to see. Now there is some limited allowance in federal law for psilocybin activity. The federal law allows for some scientific research under tightly controlled conditions. You have to get a special license from the DEA, but there are federally approved research trials. So there's ways to participate in this industry if you want to comply with federal law by doing these research trials and getting ready for hopefully federal legalization in the future. Also, in 2018, Trump signed the Right to Try Act. It allows terminally ill patients to have access to experimental therapies that have passed the initial phase of testing, but they're not FDA approved yet. Psilocybin would fall under this category. So people who have certain terminally ill conditions can access psilocybin under this Right to Try Act. Also in 2018, the FDA granted psilocybin breakthrough therapy status for research, kind of making it easier to study it and kind of putting it on a fast track. And just this year, in May 2022, the feds gave a little bit more indication that they're open to psilocybin and psychedelics. The group called the U.S. Substance Abuse and Mental Health Services Administration, it's part of the Department of Health and Human Services, sent a letter to a congresswoman who had asked some questions, and there the Department of Health and Human Services indicated that there was anticipated approval by the FDA within 2 years of both MDMA ecstasy for PTSD, post-traumatic stress disorder, and also for psilocybin for treatment of depression. So I think with a lot of the research that's been coming out recently, presents some really solid cases for how these can help people, and the federal government is opening up to this. Also, another avenue for federally legal conduct you can do in the psychedelic space is ketamine. Ketamine's Schedule 3 controlled substance, meaning it can be prescribed and used under federal law, and it's been approved by the FDA for medical use. You see a number of ketamine clinics that are doing this legally within the context of federal law, and that gives some insight on how other psychedelics might be treated if they're rescheduled. We're going to get into that a little bit towards the end here about the kind of different potential pathways moving forward for legalization. But still with psilocybin, there's a big question regarding the federal policy and how that'll work. With cannabis, we had something called the Cole Memo that was put out under the Obama administration. It basically laid out when the federal government would step in and do federal enforcement. But they basically said there that if people are following a tightly controlled state regulated system, that the federal government generally would not interfere. This isn't it wasn't a binding law. It was just sort of outlining the federal policy and giving guidelines to federal prosecutors. It laid out certain factors that would trigger federal enforcement, like interstate activity, involvement with gangs and organized crime, distribution to minors. But it gave people some confidence that they could do this without federal interference. Now, Trump revoked the Cole memo when he came into office, so it's no longer the official federal policy, but it seems like the feds have basically been following this approach since then, and they haven't really prosecuted people who are following state law. There's also a federal law called the Rohrabacher-Farr Amendment that's been in place for a number of years that actually does give people some legal protection. It prohibits the federal Department of Justice from spending any federal resources to interfere with state medical marijuana programs. So it doesn't give any protection to people who are engaged in the recreational adult use cannabis market. The feds can still jump in and prosecute whoever they want to there. But if the feds are interfering with the state medical marijuana programs, you can invoke this Rohrabacher-Farr amendment as a defense, basically, to the federal prosecution. But there's no similar protection like the Cole memo or the Rohrabacher-Farr amendment for psilocybin. We're just kind of relying on how the federal government has approached cannabis. But we're hopeful that the psilocybin will follow a similar path, but it's still somewhat up in the air. So basically, we're seeing the birth of a new industry here. It has a whole lot of potential, but the feds, if they want to, they do have the power and authority to basically squash it from the beginning. It doesn't look like that's going to be the case. Biden and Harris both have histories of pursuing punitive policies for nonviolent drug offenses, mass incarceration laws, including cannabis. Kamala Harris repeatedly opposed efforts to legalize cannabis in California. There's not a lot of positives, to go off of when you're looking at Biden and Harris's histories, but it seems like maybe they've turned a new page and they're now finally coming around and opening up to this. So there's a lot of hope out there. Just briefly to go over a couple of federal issues that have impacted the cannabis industry and are also going to impact psilocybin. First of all, taxes. There's Section 280E of the tax code. If you're involved in a federally illegal business, you still have to pay federal income taxes. And Section 280E, it established as a substantial penalty. Basically, you're not allowed to take any deduction or credit for the expenses of the business. So you end up paying way more taxes because you're paying taxes on all of your income without deducting any expenses. There have been different solutions the cannabis industry has developed here. One is to spin off separate non-plant touching entities that own, for example, the intellectual property and the real estate, and then have contracts with the drug trafficking company. Because 280 basically it only applies to businesses that directly buy or sell the Schedule 1 or 2 controlled substances. It doesn't apply usually to the ancillary businesses. So there's ways of structuring it to minimize the 280E tax burden. The other issue that's been a big problem with cannabis is banking. Cannabis companies, they frequently get their bank accounts shut down. There's certain banks that are open to working with cannabis clients now. There's more of them out there, but still it's a dicey situation with the banks not wanting to be violating the federal law themselves. There's something called the Bank Secrecy Act that banks have to deal with. It actually requires banks to violate the secrecy of their customers by providing reports of suspicious activity to the federal government. So when banks know that one of their accounts is being operated by someone doing federally illegal cannabis transactions, they have to file these reports. But in 2014, the Financial Crimes Enforcement Network, part of the Department of Treasury, it gave guidance in writing to banks who are wanting to work with the cannabis industry. It said basically they can do it, they can work with cannabis companies, but they have to do certain due diligence, make sure they're operating within the confines of state law, and then they have to file one of 3 different types of reports, depending on whether they seem to be complying with state law or whether there's other red flags. But despite this guidance, a lot of banks have still been very hesitant to work with cannabis companies, and there have been talks about different solutions in the work to provide banking services to cannabis, but none of them have really panned out yet. But we know that psilocybin businesses are going to face these same banking issues. It might be a largely cash business unless we see banks starting to step up and willing to open up to work with this industry.
Thanks, Raza. Joe, from your perspective, what can be done, expanding on Raza's thoughts just expressed, to help promote other states coming online with regulated psilocybin problems, and to change federal level policy relating to psilocybin?
Few things. So folks can really get active in their own cities and counties, working towards their own decriminalization bills. And that shows the state that people are actually really serious about that when it goes through. So the state level politicians will take it far more seriously when we get to that level. So folks should organize and try to get ballot measures through, voter initiatives through, if your state allows that kind of thing. And that is very possible. There's a lot of groups out there that can help you with that. And one of my favorites, Tom, is Psychedelic Medicine Coalition, where we're actually trying to fund, get federal funds dedicated directly to psychedelic research. And once we get more research, there will be far less argument from anywhere that this stuff doesn't have any medical value in the current categorization. So I think those are some big things that we can do, and just start hosting, film screenings, little conversations, bring in a speaker from a couple towns away to talk to you about it. I think there's a lot of small moves you can make to really change the trajectory here.
Thanks, Joe. And for those who don't know, the Psychedelic Medicine Coalition is an association based in Washington, D.C., run by Joe and my friend Melissa Lavasani, that's focused on influencing federal policy relating to psychedelic substances. So it's a wonderful organization, and we encourage you to look into it. Joe and I both sit on the boards of that organization. So we're running out of time here, and I want to leave some time for questions. There's a lot more to cover here. We're not going to cover it all today. Lizzie, I'd like to wrap before you open up for some questions here. As to what's coming up in Oregon and Colorado on the psilocybin regulation.
Yeah, so with Oregon, as we've mentioned, that they're open for applications right now. So I think it's really just seeing how that process goes and how long it takes. And once applications are approved, build outs and making sure that operations are in place. So there are quite a bit of steps to take, but I'm hopeful to see the psilocybin services sometime this year in Oregon actually being provided. And in Colorado, we will be working on developing the framework for regulating the cultivation, manufacture, distribution, and sale of psilocybin and the provision of services. So a couple dates to keep our eyes on that were actually written into Prop 122 would be at the end of this month. By the end of this month, the Colorado Governor Jared Polis will need to appoint 15 members to the Natural Medicine Advisory Board, which will advise the Department of Regulatory Agencies, who is in charge with overseeing the Colorado program, on the implementation of the program. So we'll keep our eye on who is going to be appointed by the end of this month. By September 30th, 2023, the advisory board's first recommendations to DORA are due. By January 1st, 2024, DORA must adopt rules establishing the qualifications, education, training requirements for facilitators, and to approve any required training programs. And then finally, September 30th, 2024, which I know seems like a long time away, but I think it will go quickly. DORA must adopt the rules for the program and also start accepting applications on that date. So very exciting things with both Oregon and Colorado. We'll see how the application process goes in Oregon and how the rules are developed in Colorado.
Thank you, Lizzie, very much for that. And let's move to some questions here. So we have a few in the chat window. Please feel free to introduce others, and we'll see if we have time to answer them. I'm going to take the first one myself, actually. It's from a Melissa Dean. Hi, Melissa. For a young lawyer in a state like Florida, what advice do you have for getting a foot in the door with legal practice or just getting involved in general? So, Melissa, the first thing I would suggest is perhaps considering getting barred in Colorado and Oregon, and that's a very high threshold, but that would be my first answer. South of that, I would say two things come to mind. One is perhaps getting involved in, and pardon me, but I'm going to do it. I'm going to make a second plug for the Psychedelic Medicine Coalition. It is a wonderful organization. Melissa Lavasani is a true thought leader nationally on the psychedelics front. But it would be to get involved with that or another organization like it, right? Because that federal conversation applies to all of us. And it's a way to get your feet wet in terms of becoming engaged with the subject matter. And I think that there will be a gravitas perhaps that you could import, if you will, into Florida, should Florida, when it comes online. I'm hopeful that it's a when, not an if. And that's my own personal hope. So that's one possibility. Another one, short of actually getting barred in the states that Colorado or Oregon, is actually maybe getting in the back door through cannabis. Right, there are so many parallels between cannabis and psychedelics, and even the inconsistencies between cannabis and psychedelics are instructive and informative. So I think if you were to get involved in a cannabis context, if you were to start providing those services, you're going to find that a lot of those skills, a lot of those assets, and frankly, a lot of those connections, because there's quite a bit of overlap in these industries, will be applicable to a psilocybin practice in the state of Florida. So those are the first things. And then also, yes, I would pay lots of attention to the notion that it is illegal at the federal level. Psilocybin and some of these other medicines are still mistakenly, in my view, residing on Schedule 1 of the Controlled Substances Act. So you do need to give due consideration to that. And I encourage you to spend a lot of time focusing on that and what it means for your bar license. We have more questions here. So I'll go ahead and go with, I think Ryan Irving might have been next. This is a question for Joe, Raza, and Lizzie, our panelists. In the various states, is it legal to ship or deliver product to customers, or do they have to go to a retail location or clinic?
I can answer part of that. For Oregon, you have the psilocybin services. So when a person wants to use psilocybin, it has to happen at a service center, at a licensed service center. It can't be sent to you. There are different options for, group outdoor settings and things of that nature, but it has to happen at a licensed service center. Colorado, we still have to see what the regs look like, but in either state, I wouldn't recommend shipping psilocybin, even if it's from a manufacturer to a testing center. But that's, getting into some of the details. So in short, I would say you have to go to a service center, and then in Colorado, it will be healing centers, and we'll see what the provision of services at private residence will look like.
And I would just say a lot of people have been prosecuted for shipping controlled substances, especially if you're using the U.S. Postal Service. You can't do federally illegal activity there, but I would definitely stay away from shipping the Schedule 1 controlled substances.
That's a big no. The next question, I believe, was from Jennifer Clemente. So hi, Jennifer. The Church of Psilomethoxin claims that they are legally protected because the chemistry of the creation renders both psilocybin and 5-MeO-DMT undetectable. Have you looked into this new entity, and what is your opinion?
My opinion on the molecule is that it's going to be tested in court. These people are getting really loud. I'm curious about it, but I would be most concerned about the Federal Analogs Act and how that might be ruled on. So that is a rule where is the molecule substantially similar to another molecule that's already scheduled? And it doesn't necessarily mean molecular structure. It could be the experience as well. So it's really, in my mind, a little iffy, though I'm very interested to learn more. I would just urge caution on that front.
Thanks, Joe. The next question, I believe, is from Matthew Brockmeyer. Hi, Matthew. Prediction, which state decriminalizes next?
If I had to put money on it, California.
I put my money on the same state, Joe.
There was actually a proposal in California a couple years back that a lot of people had hope in, but there was enough opposition that it kind of died out. But I think that there are a number of states have these proposals in the works, and if Oregon goes smoothly and Colorado, I think you'll start to see a number of different states following in their footsteps.
Great, and we're running out of time here. Let's see if we can answer one more here from a Christina Hoogland. Hi, Christina. Christiana, pardon me, Christiana. In Colorado, are licensed facilitators using synthesized psilocybin or naturally growing mushrooms containing psilocybin? Do we know if it does have to be synthesized is the future of psychedelic medicine? Do we know
I
if
can
it's...
speak to that one.
Go ahead, Joe.
Yeah, so it's actually interestingly vague. I think the law specifically names psilocybin and doesn't name mushroom-derived psilocybin. So I think it is inclusive of both, whereas Oregon was only mushroom only. So there's some interesting things. Again, this is all going to have to be tested in court, and there's going to be new regs coming out for the legal avenue. So, play safe when you can, folks.
We are out of time, so unfortunately we can't answer any more questions, but I'd like to thank all of our panelists. Obviously, a fabulous panel. Joe, the CEO of Psychedelics today, I think one of the true great companies in this still nascent industry. So Joe, thank you for your leadership and also for your participation on this panel. And then Raza Lawrence, who's my colleague at Zuber Lawler, and Lizzie Fonkboner, another of my colleagues at Zuber Lawler. Thank you both for your wonderful insights. Greatly appreciated. And it was a pleasure to step in. I'm going to give another shout out to my co-founder of Zuber Lawler, Jeff Zuber, the head of our psychedelics practice. He is again under the weather, so I'm pinch hitting for my co-founder, Jeff Zuber, and I'm delighted to do it. And finally, I'd like to thank everyone here for attending. Thank you so much. It's obviously an exceedingly exciting conversation, and these substances really do have the potential to dramatically improve the human condition around the world, and it's a delight to engage in this conversation with all of you. So thank you very much. Thank you to my colleagues at Zuber Lawler. Thank you very much, Psychedelics Today, not just for this panel, but also for your leadership.